The Nigerian Bar Association has moved to stem the penchant by its members to collude with politicians to abuse the judicial process in Nigeria. In a statement on Monday, NBA President Akpata condemned the increasing spate of contradictory court decisions and orders, especially among courts of coordinate jurisdiction. Akpata also blamed members of the association for allowing themselves to be used by politicians who engage in forum shopping and bring the judiciary to disrepute. The NBA president said the association will seek audience with the Chief Justice of Nigeria, Justice Tanko Muhammad, in order to address the malaise holistically. His statement came on the heels of the summon of 6 chief judges of Rivers, Cross River, Anambra, Kebbi, Jigawa, and Imo states by the CJN to explain the indiscriminate orders granted by their courts. To discuss the proposed engagement with the CJN and how the NBA can work with the judiciary to nip the problem in the bud. We're now being joined from Abuja by Monday Ubani, chairman of the NBA section on public interest and development law. Mr. Ubani, among others, was nominated by the NBA president to be part of the delegation for the proposed meeting with Justice Tanko Muhammad. Good morning, and thank you for joining us, Monday Ubani. Good morning.
Yeah, thank you, Dr. Ruben, El-Rufai, and then our sister, Tudo.
You call him El-Rufai. He's Rufai. Rufai was saying El-Rufai is in Kaduna.
Oh, yes, Rufai, my good friend. Thank you very much. Thank you very much, yes.
Yeah, but it's good to have you on the program. Very quickly, we just want your comment
Thank you very much.
on the reaction of the NBA and the CJN to what looks like an abuse of procedures, an abuse of interim ex parte orders by judges and also by lawyers who are forum shopping, jumping from Port Harcourt to Kebbi, back to Calabar, all over the place. And be reminded that only yesterday, another judge in another matter in Port Harcourt granted another ex parte order barring the Edo State government from making COVID-19 vaccination compulsory. Do you think that the NBA intervention or the CJN intervention will make any difference? Because these judges don't care anyway, the lawyers don't care anyway. So why are they so contemptuous of procedure?
Thank you once again, Dr. Ruben. The point is, even in the Bible, when sins are not punished, men tend to exercise what we call impunity in doing most of the violations of rules and regulations. So I think that the NBA and then is taking the lead. In fact, the conference we are having this year in Port Harcourt, sometime in October, the central team is taking the lead. And we have agreed that the legal profession must actually start by disciplining its members in terms of violations of our norms, of our ethics. And I think that what the president has done in the circumstance, by raising the alarm and then decrying what has happened so far with some of these ex parte orders, is clearly something that is commendable. And his process and procedure of, first of all, having an audience with the CJN of the Federation, I think is also proper. Now, we have also started by looking at those processes and the rulings, those contradictory rulings that has actually been given by those various courts, in order for us to look at it holistically and then make appropriate recommendations with regards to if there are disciplinary measures to be taken against any of our erring members. And I think that is the way to go. To me, the process has just begun. And we want to set example in this country as a profession that we will not allow some of our members to derail our system, either our democratic system or our systems generally. And the issue of discipline members who are actually in the profession, who ought to go and uphold their ethics and rules and ethos, but who go there to actually violate it flagrantly, that it cannot be business as usual. So I am totally in agreement with the process and procedure taken by the president so far. We want to have an audience with the CJN. He has invited the chief judges of the various states. We thought that the people that should have been invited actually are those judges that are clearly in error. The issue of ex parte orders, there has always been a directive by most of the chief judges of the various courts of jurisdiction that we should exercise some level of caution and restraint in issuing ex parte orders. That the issue of fundamental fair hearing, which is a constitutional issue, must always be accorded every party. What I see most judges do most times is to say, look, put the other party on notice. As long as there is nothing to preserve in terms of urgency, preserving the rest, why can't you allow the other party to be heard? Starting from the Port Harcourt judgment, it's very curious that a judge could remove a substantive chairman of a political party by ex parte order. That is where the dance of the madness started. Now, the proper thing to do is that if that order is even procured wrongly, is to go on appeal and have it set aside, or even approach the same court to set aside that order on the grounds that it may have been given clearly in error because of probably some wrong information that was given to that judge. But not to now begin to go for forum shopping to KB, from KB to all over the country. Now, the judge now in Cross River State now compounding the matter by now reinforcing the order of the High Court of River State. To me, clearly, these things are clearly dangerous. They are strange. You know, I don't see the reason why a judge who knows the jurisdictions of court, who knows the issue of hierarchy of court, who knows the issue of court of coordinate jurisdiction, we keep on giving some orders that sound so strange, even in the ears of the common men who are not learned. They look at it and say, what is going on? Is it that any person can just saunter into any court and procure judgment, you know, at will and at the will and caprices? It makes a mockery of the entire system, and that's why everyone is raising eyebrow. That something has to be done, you know, practically to really, you know, reduce this particular madness that is going on. Because to me, it is pure madness, and we cannot allow this to continue in our country.
Well, thank you, Mr. Ubani. I have a pretty good idea of what those reasons might be. But how far is the NBA going to go? Do you foresee the errant lawyers being invited by the NBA's disciplinary committee? Do you foresee anybody being struck off? How seriously will the NBA take this?
Yes, we have started. The most important thing is to get those processes and look at the rulings of the court. The committee has had a preliminary meeting. This committee that is set up by the president of the Nigerian Bar Association is chaired by a very learned and senior lawyer, Mr. Ajibade. Ajibade is a senior advocate of Nigeria. Another member of that particular committee is the chairman of section of legal practice, Abimbola. Abimbola used to be the Attorney General of one of the Western states. He's a member of that committee, and then I am a member of that committee. I'm the chairman of section of public interest and development law, as rightly pointed out by Dr. Bati. We will look at those processes and look at the rulings of the court, and then probably make a recommendation to the president who has set us up to look into what actually transpired. What are the processes? What were the reliefs that these lawyers were asking, and what were the rulings that the courts gave? You know, if we don't get into that, we can't now begin to pass any judgment against any person. So we have to look at the entire processes and the entire thing holistically, and then make a recommendation to the NBA. From there, we begin to see whether we can get some level of discipline on certain erring lawyer. But we must find out that they have erred in the first place. But on the face of it, it looks curious in some of the processes and procedure. Oh, that a judgment was given in reverse. Then somebody had to run now to KB in order to now stop that stay on order of a high court in Rivers. We know the process and procedure is that you would have come before the same court in Rivers in order to ask for a stay. But you now had to run to KB, and KB High Court was the one now staying an order that was delivered in Rivers. And then now saying that he's granting leave, you know, to the chairman of the political party to go back to his office. Then again, that is strange, because it's like he's sitting on appeal over the judgment that was delivered in Rivers. Then the man in Cross River now came and gave a reinforcing order. You know, so the entire thing is strange, even for those who are not learned in law. It sounds a bit strange, you know, that, and all these orders are being given ex parte. That is also what makes the entire thing very curious.
Right. So I'd like to ask, is it just for what happened recently? Because a lot of people are clamoring for you to, you know, beam this your investigation searchlight to many years from now. Because this madness has always been in our system for as long as I can remember. So is there a possibility that you might also maybe like take a 5-year or 10-year course, really look backwards? Or it's just for this specific event, you know? And is it going to involve all the shenanigans that happen around Anambra and the candidature of some people in Anambra? Because this has gone on for way too long. And we can stretch it back maybe 4 or 5 years from now, because something has to be done. And this has to be sanitized in the first place. And secondly, will be what role can technology play? I was really, really shocked when I heard that we've not been able to incorporate technology effectively in our legal system. You know, take for instance, maybe we have a cloud platform where injunctions are put up there that even if you claim that you didn't see the injunction given in an Anambra court somewhere, you'll probably see it on the platform and you'll know that you cannot put another, preceding injunction. And the fact that a lot of judgments are still written in, with pen and paper and the likes, the drudgery, the very crude nature of the judiciary, are we going to look at this too?
Yeah, Rufai, you are very correct. The terms of reference include the madness that also took place in Anambra, especially with the Abga cases. I think it started also in Anambra, and then they went to Jigawa, from Jigawa to Imo State and all that. So we are also looking into the process and procedure that took place in that particular regard. And of course, remember that the Court of Appeal, Justice Iheme, had to make a pronouncement, and she specifically, mentioned the fact that the lawyers and the judges, that engage in this forum shopping and engage in these judgments that look so strange and curious must also be investigated. She started that process, and Spidel issued a statement in that regard and said, look, we must begin to really look into our professionals who, in the course of doing their duties, are being actually used by politicians, and their intention is to derail our political process. It got to a state that INEC had to cry out, look, we are totally confused. We don't know which of the others now to obey, until the Court of Appeal, both in Anambra and then the one in Kano, had to set the tone. We are waiting for the one now, the Court of Appeal decision from that will emanate from Owerri, I think, because there was a decision that also emanated from Owerri. So the INEC is clearly put in confusion with all this. I do not believe that most of the judges that give these contradictory orders are not aware of the existing order that have been given by the other courts, because they make references, to all those rulings. They usually make reference to the previous judgment. The one in Kebbi made reference to the judgment that was given in Rivers. The man that also delivered his own judgment in Cross River made reference to the judgment that was delivered. So most of them were really aware. And the lawyers that actually filed those processes also, they are aware of all the rulings that have actually happened previously before going to all these courts. So I believe that there is not for want of not being aware. I also believe that what you said about technology is very key. We should deploy technology in our judicial process, which is what I heard that the federal government is trying to do now. We need to deploy technology at all levels, both at the state level and at the federal level, with our judicial process, so that people cannot have any excuse. Oh, maybe we're not aware of the existing judgment because we had issues previously where Court of Appeal will be giving contradictory decisions on the same matter, virtually by the fact that they may not be aware of another has been given another jurisdiction. So we must deploy technology in the application of our laws in order to ensure that all those excuses does not exist. But as I said earlier, most of these judges, most times, they are really aware of some of the previous decisions, but they still go ahead and do whatever they want to do because of the level of impunity. If we don't punish crime, if we don't discipline people, there is no way this thing will stop in the country. I want to start by saying that you are very correct that it didn't start today. If you remember what happened sometime in 2015, this matter took place in Abuja here. The Federal High Court, presided over by Justice Aban, gave a judgment in favor of one Uche Oga to emerge as the governor of Abia State against Okezi Bazu. Somewhere in Isialangwa or thereabout, somewhere in Abia State, a High Court came up in the evening and gave a contrary decision and stayed the order of the Federal High Court. We wrote a petition to NJC then, presided over by Justice Onogin, over the kind of madness that took place, because we felt that that was clearly wrong. You cannot stay an order of a court of coordinate jurisdiction. And nothing came out of that particular petition. The petition was dismissed, even with all the fact that was available that the man had no right in faraway Isialangwa, where somewhere in Ungwaland, in Abia State, to give a contrary order to Federal High Court judgment. So it's not today. There has been a build-up. Of course, you remember also how Supreme Court also assumed jurisdiction over a matter that should have ended at Court of Appeal. We're all aware of what happened with that particular case. So it didn't start today. But if we now as a nation want to come down and say, look, let's begin to look at issues like this and begin to address them and correct ourselves so that we don't continue to derail our system with the kind of thing that is going on. It's fine and good. And I'm happy that the NJC itself, presided over by the current Chief Justice of Nigeria, is worried to the extent that he had to invite the chief judges. The NBA is now worried. Everyone is being worried. Everyone is being worried because we have to actually rescue our country. We cannot continue doing things wrongly and expect the nation to be respected. You know, we are being watched. The world has become a global village. So I think that the best thing is for all of us to have conscience and say, no, we can't continue on this road. The road we are treading upon is very dangerous. And we cannot continue as a nation to begin to do wrong things and expect that nation, you know, to actually, you know, receive the commendation and accolades, you know, from other nations in the entire world. And I think that is the best way for us to go. The journalists must be involved. The lawyers must be involved. The judges must be involved. Everyone must be involved. We must all know that this nation requires rescue, and we all have a role to play in rescuing this nation. And I'm happy now that NBA, under the leadership of Mr. Akpata, is taking this bold step, you know, in ensuring that things are done properly within the legal profession. To me, it's joy, joy, joy. I'm so happy about it, and I will want to be part of it in order to participate in the sanitization process.
Okay, Monday Ubani, you are very correct. Yes, it didn't start today. As far back as 1985, we had CJN Mohammed Bello at the time complaining about these same ex parte orders and their abuse. Under General Sani Abacha, we had a notorious court granting an ex parte injunction at midnight over the 1993 June 12 elections. And then, of course, that has been the case all this while. But what gives you the impression that the intervention of the NBA and the CJN will make any difference? With regard to the Chief Justice of the Federation, we're dealing with an irony. I think I wrote in the back page of This Day yesterday that the CJN himself is a beneficiary of an ex parte order, which removed Justice Walter Onogen from office as CJN. So what is the guarantee that Justice Tanko Muhammad, as chairman of the National Judicial Council, will be able to make this change that everybody is talking about with all the issues that have come to a head? And you've been talking about discipline. What kind of sanctions will you recommend for lawyers who are guilty of forum shopping, those ambulance lawyers, including senior advocates of Nigeria, who seem to have forgotten the basic rules of procedure? And then, of course, the judges who play possum when they are faced with critical issues of jurisprudence.
The current CJN is occupying a position of honor. He is now in a very big position to effect some of the changes he may have contemplated, you know, while, you know, being at the bench. To be a CJN of the Federation is a very big position. So I think that now that he is here and he is probably listening to people and, of course, knows how Nigerians feel about the current happenings, he is in a better position to effect changes. He can be a beneficiary of a wrong, but he comes in. We've seen what happened in South Africa. Some of them were, you know, beneficiaries of the apartheid system, but somebody sat down there as the president of South Africa and changed the entire system. So I believe that the current CJ is clearly a man of honor, a man of integrity, and a man who wants to be remembered for some level of legacies he will leave behind as a CJ. So now nature and circumstances has bestowed upon him that opportunity to do this thing at this point in time, and history will be very, very fair to him if he succeeds in effecting some of those changes some of us are crying for. The issue is that whosoever has wronged the system must be punished. I remember that the judgment you mentioned, the judgment that was obtained in midnight, the NJC then took a very hard position on the judge, and I think the judge was removed. Eventually died in in a manner that was considered not too decent. So there has been processes all this while where judges who have erred have been punished by the NJC, but over time we overlook certain persons, and that created some level of impunity, But I know that there have been times in time past, where judges were punished by NJC. We have had history, we have stories, and we have evidences. Now that it has happened under this present circumstance, I think that the best thing that can happen is for the NJC to be very bold enough to take decision against some of these judges who have actually erred gravely, and whose lifestyle, if allowed, will actually derail our system. Then the NBA itself also must, as a body, begin to really discipline some of our erring members, especially senior lawyers, who do certain things that we consider clearly unethical, because by the level of training and experience and knowledge, there are certain things you don't expect a lawyer to do, especially some lawyers going back to Supreme Court. Sometimes to ask Supreme Court to overrule itself in a judgment that has been delivered over the same matter, not a different matter entirely, asking Supreme Court to, sometimes we look at them and say, what is going on in the system? Is it that because of the fact that they are so big in the system and the system cannot punish them, that they do some of those things that we consider very strange? So I think now that NBA under Akpata is really very, Akpata is worried. I had a meeting with him recently, sir. Let me just give you an idea of how he thinks. Akpata have an idea that before he leaves within this 2-year period he has been elected, that he's going to do some things in the judicial sector, that will really, leave a big legacy. One of them is the issue of recruitment process of the judges, that we must really overhaul that system, because we need to. If we don't, we keep on crying. Most people who are judges in Nigeria today do not have interest to be judges, but they are nominated by either the governors or the senators or the Ezes or the Obas or the emirs. The people who have no interest whatsoever, and they have no inclination to be a judge, but you now make that person to be a judge. So we need to review our recruitment process of justices in all the various courts. We need to, and Akpata is feeling that he has to contribute that, his own quota. We also have to look at lawyers generally. As I said earlier, part of the topic we discussed is that the lawyers must take the lead in discipline itself. We must, accountant must follow, other people must follow. Whoever go into public service, must reflect the ethics of the profession. You don't go in there and do all manner of things and come back and join the particular profession without any discipline. From now onwards, the lawyers are feeling that those we send, attorney generals or those who are governors, whatever they are doing, we are watching them. Whenever they want to come back with system, we look at them and say, no, you didn't represent us well, and for this we are going to punish you. That is the way for us to go as a nation, punishing professionals who go and occupy public office and do wrong things and come back into the profession and then come in and then they accept it. No, we must begin to lay good example by saying, no, you cannot go and represent us wrongly and want to come and join us, but we must begin to punish people. That is the way for us to go as a nation. And I think that this time around the NBA is serious, NJC is also very serious. Hopefully, I believe.
What about a month ago, INEC called for the NBA to wade into this same issue with regards to the November 6th Anambra elections, conflicting judgments, ex parte orders, threatening the elections in Anambra. What was the NBA's response? Because it does not appear that that call got that much traction and that real action was not taken until this PDP morass occurred. What was the NBA's response then? And what do you say to the threat to the Anambra elections in November 6th posed by members of the legal profession?
That is not true that NBA did not do anything. There was a statement issued, and I had the permission of the NBA president to do that under Spidel. We issued a statement, we condemn, and we said that the NBA, we take practical steps. It is based upon that we even suggested that can we even begin to discuss the issue of our colleagues, who occupy positions of authority and then they clearly breach our ethics. Can't we now begin to put machinery in place to punish them? That is how that topic, and I told you now that it's going to come up within our conference, came up. And also, this particular incident that took place now with Secondus as the chairman of PDP got NBA thinking, and the president said, no, we cannot continue. INEC has called us out, and we issued a statement believing that the madness will stop. Now the madness has not stopped. We now have to go the entire hog by reining in our members, and bringing them to level of understanding that this is not the way for us to go as a legal profession. So I don't think that MBA kept quiet. You know, MBA was really ruminating over the issue and taking some practical steps. And this now has culminated in that statement that was issued, you know, asking that we have a meeting with the CJN of the Federation in order for us to look at this issue holistically and probably profile a more practical solution to the problem. It's an intractable problem, but it's solvable.
So I want to talk a little bit about MBA politics now. So there was somebody here yesterday that was speaking, and they said, oh, MBA should be careful so that you don't go demonizing, you know, senior lawyers, SCNs and the likes and things like that. And most of the lawyers, you know, that have been fingered in all of this process are definitely SCNs. I mean, so when they see you people set up a committee like this, hope that dichotomy issue will not come into play. I mean, Professor Ubani, I know you're not an SCN, and your disciplinary committee is handling something that will involve an SCN, and you might mete out punishment to the SCN. Isn't it going to bring a case where the SCN will look and say, who is Ubani to do this? To be part of this and talk to me like this? Who is even the president, Akpata, to talk to me like this?
That is an interesting angle I just brought. In the legal profession, seniority is very key. I'm over 30 years at the bar. I was called to bar in 1990. I'm a very senior lawyer in the first place. And so we are not even engaged in disciplinary action. We are looking at the act and conduct of our colleagues. I'm a chairman of a section, a very important section in MBA. Akpata is the president of the bar. Whether he's the senior advocate of Nigeria or not, that is not the issue now. He is the president of the bar. He is the #1 lawyer as I speak to you in the country. And there is no provision in our law that says for you to be a president or for you to hold any position in Nigeria, within the bar, you have to be a senior advocate of Nigeria. There are issues, there are considerations, either seniority, you know, experience at the bar and all that they put in before they appoint you into anything. And so when it talks about, when you are talking about senior advocate, I don't think there is any senior advocate of Nigeria that has erred that cannot be brought to book based upon our structures that is in place. We have the disciplinary committee that is headed by senior lawyers too. So we are not even talking about that we have the power to discipline. We're only looking at what has happened and then making a recommendation to the president who will be in a position to take some legal steps, including referring the matter to the disciplinary committee. So there are process and procedure. We're not even talking about disciplining any lawyer now. We're looking at the issue and then we'll make appropriate recommendation. So that dichotomy is clearly imaginary. I mean, I'm talking about issue of senior advocate of Nigeria. And for any MBA to give you a job, they must have looked at your antecedent, they must have looked at your history, they must look at your years of experience, they must also look at you're not a small boy within the bar. So if you talk about senior lawyers in the country today, I think Barrister Ubani qualifies to be a very senior lawyer. 30 years at the bar is clearly not a joke. As issue of sonship, it is a matter of time. It is whether do I even desire it in the first place? Yeah, you know, but now that everyone is saying, Mr. Ubani, you have to be a senior advocate, I'm taking a look at it, and by the grace of God, I'll also be a senior advocate. So I don't think lawyers really, you know, dichotomize on the issue of senior advocacy, you know, before you can do anything. No. The MBA today president is the #1 lawyer, and he has the authority and he has the power and the confidence of all lawyers to take any action against any lawyer, including senior advocates of Nigeria. There is no such dichotomy. It's clearly imaginary. And whoever told you that is clearly, you know, on his own. It's clearly his own perception. There is one legal profession. And today is headed by Akpata, who is a very senior lawyer too. He's over 20-something years at the bar. So he's not even called yesterday. He's over 20-something years at the bar. Well-experienced lawyer who has actually achieved his own. He's one of the best lawyers in this country in terms of practice, in terms of wealth, in terms of knowledge. You can't put him down.
Wealth.
So I don't think that dichotomy exists.
Ubani, you have to stress wealth. Non-lawyers.
You have to flex the muscle, my brother. Thank you.
Anyway, thank you very much for joining us. We will have loved to ask you more questions, particularly with Justice Mohammed. You know, granting an ex parte order against the Edo State government on the decision of the Edo State government deciding to make vaccination for COVID-19 compulsory. Colonel Saretin, who took the case to court, act on behalf of all the people of Edo State. But we don't have more time. But we thank you very much for the interaction with you.